Good day, everyone, and thank you for joining me today. My name is Dr. Renuka Thakore, and I'm founder of Global Sustainable Futures Network. I'm based in United Kingdoms. Thank you for joining me today's session on property law and blockchain application in international law and legal policy. In this discussion, we will explore how blockchain technology is transforming the landscape of property law globally, redefining ownership, transaction processes, and dispute resolution systems. Our goal today is to examine both the opportunities and challenges this emerging technology, blockchain, brings to legal frameworks and how it may shape the future of property rights and governance against jurisdictions. So today, our objective is to explore how blockchain technology is revolutionizing property law and influencing international legal frameworks. We will cover some key topics such as blockchain-based and asset blockchain-based land and asset registry, the role of smart contracts in property transactions, and decentralized property governance, regulatory considerations, and the potential for blockchain to streamline dispute resolutions. Each of these areas are crucial in understanding how blockchain is reshaping the property rights and legal systems worldwide. So let us see what is blockchain. Blockchain is a decentralized, immutable digital ledger that securely records transactions across a network of computers. When applied to land and asset registration, blockchain serves as a transparent and tamper-proof system for storing and updating property ownership records. One of the most significant benefits of using blockchain in land and asset registration is the increased transparency it brings. Every transaction is recorded and cannot be altered. Even the historical transactions cannot be altered, which generally helps in preventing frauds. It also makes land administration processes more efficient by reducing paperwork and speeding up ownership transfers. Importantly, blockchain improves access to the property records for all stakeholders, whether it might be citizens, governments, or investors, making the system more inclusive, accountable, and transparent. Let us see one example here. And Georgia has been a leader or has been, foremost country to adopt these technology. The National Agency of Public Registry has partnered with Bitfury to implement a blockchain-based land titling system. And this has allowed for secure and transparent property transactions with digital records that are cryptographically secured. And they have helped to reduce disputes and improve trust in the land registry. So let us see what are legal implications of blockchain land registry. Blockchain strengthens property rights by creating immutable and transparent records, which offer a high level of protection against tampering of or fraudulent claims. This has the potential to significantly reduce legal disputes over land ownership. For example, in Kenya, double allocation scandals, meaning Overlapping claims on the same parcel of land have led to thousands of legal battles, and often they are caused by fraudulent title duplications. And a blockchain-based system could help prevent such duplication by ensuring that only one immutable record exists per parcel. However, challenges remain. One major issue in the integration of blockchain with existing legal and registry systems is that many of which still rely on paper-based or outdated digital records. There's also the question of national sovereignty and how blockchain-based property records are recognized internationally, especially when legal frameworks vary widely across borders. For example, Germany has expressed strong regulatory caution around blockchain land registries. Its legal system emphasizes centralized, government-controlled land records. And the German Federation Ministry of Justice has raised concerns over the lack of legal certainty and data sovereignty, and currently does not legally recognize these decentralized property registries as a substitute for traditional national processes or notarized processes. So let us see, some of the applications. For example, smart contracts. What are they? Smart contracts are self-executing agreements where the terms are directly written into code and deployed on a blockchain. Once these conditions are met, actions like payment or property transfer are automatically triggered. They are decentralized, meaning that many people are acting on it and they are like where they are created, it might trigger the transfer and the point on everyone's computer. These contracts now can be streamlined in property sales, lease agreement, and ownership transfers. For example, upon receipt or payment, the contract can automatically transfer ownership. It can minimize legal and delays and human errors. It can also reduce intermediaries. Smart contracts reduce the need of traditional intermediaries like lawyers or notaries, which are significantly cut cost and transaction times. They are also legally enforceable. However, a key challenge is ensuring that smart contracts are recognized and enforceable in the jurisdiction that you are applying. And they are enforceable across different legal systems. Because as I gave an example in last slide, that Germany does not accept this as a legal system, it might require that traditional documentation should be additional burden to the player. And these documents could be human oversight, creating a legal gray area for purely digital agreement. So it has to be a legal system in any countries or all the countries that it is executed. So limitation of automation, there are, of course, when we are dealing with digital and emerging technologies, there are definitely limitations. While smart contracts can automate straightforward processes, many property transactions involve complex legal nuances, and that cannot be easily readable by the machine learning or the language that we are putting in the form of blockchain. And therefore, the conditions, expectations, and subjective interpretations, they are very difficult to encode. And therefore, we must look at each and every contract individually to understand how we encode it and decode it. For example, contract clause that depends on reasonable use or good faith may require human judgment. What you mean by reasonable? Because the reasonable could be reasonable for me, but could not be the same for the other party. Good faith, again, that is very subjective word. What is good for me may not be good for the others. So we need to look at these subjective matters and understand them, how we decide objectively on this, or how an objective or automated system can work with such phrases. We also need to look at legal compatibility. Smart contracts often operate in isolation from national legal system, and therefore, if a dispute arises, it may be unclear how traditional contracts law apply, and especially if no written agreement exists outside the code. And therefore, it is still a double impact. I mean, we have to work in both systems simultaneously until we get to the mature system of this blockchain. Jurisdiction issues, as I already mentioned, few countries do not recognize it as an legal system, and therefore property transactions are highly jurisdiction specific, and therefore it does not allow to be applied to all the countries. So executing a smart contract for land in one country by a party in another can raise serious legal questions. And therefore, we need to understand which country's law govern the contract and how it is enforced and how it is handled in each country or of that parties. And there is high inconsistent across the borders. There is no global standard yet for smart contracts, and therefore there is a lack of consistency, and this creates uncertainty between the contractors or the parties, and the risk is high for international property deals when it is conducted via blockchain. So still, it is in infancy and not widely legalized with a smart legal system, and therefore we are lacking its applications around the world. However, blockchain is important to understand as an emerging technology for the huge work that we would undertake with so much population and the properties and other estates that needs, registry. Blockchain enables the tokenization of real estate and other assets. It allows them to be divided into digital tokens, and this allows for fractional ownership. This is very important with growing economy where we are having a sharing economy and so on, where you must have come across the example of Airbnb, where the property is owned and shared, and this type of economy or this type of contractual agreements will be more and more in future, and therefore we need to have this understanding of how it would work on fractional ownership, where individuals invest in parts of a property, similar to owning shares, making property investment more accessible and liquid. This challenges the traditional single title model of ownership, and therefore it is important that multiple token holders may collectively own properties. Governance can even shift to DAO, which is Decentralized Autonomous Organization. And these would impact your decision making. In decentralized autonomous organizations, decisions are taken like, who would maintain the property or who would sell the property. And these all shares can be made through this tokenization or blockchain-based voting. However, the biggest hurdle is legal recognition, as I have been repeatedly highlighting here. Most jurisdictions still require formal registry of real estate in government-led systems. The law doesn't yet fully recognize token-based or fractional ownership, making enforcement and transfer of rights problematic in many regions. So across the globe, regulatory responses vary. The EU emphasizes data protection and blockchain's alliance with GDPR, whereas in US, regulation is fragmented across states. And with the pilot projects in places like Vermont and Arizona, it is still more difficult how to integrate between the states and then at a central country level. In parts of Africa, like Rwanda and Nigeria, governments are exploring blockchain for land governance, but they face infrastructural and legal capacity challenges. You might know that African countries are still not capable for digitalization because they are dealing with the problems of electricity and internet. So basic essential facilities are needed, and the cloud and data protection and all those regulations are still in infancy in many countries. And so this all infrastructure is needed for blockchain to mature and to be executed at a national level. National government may align blockchain-based systems with existing property laws and ensure compliance with regulations around data privacy, security, and record retention. There are also questions about how these systems fit into the current legal evidentiary standards. And therefore, the government's role is very crucial. A key debate is how much control government should retain. Should they act as a regulators or a certifiers or both? Or should they have a self-regulatory system by decentralizing the networks? So most governments are still cautious, preferring hybrid models that balance innovation and oversight. So they are still learning. This system is being studied by several stakeholders. And so one of the blockchain's core strength is immutability. That is very, very important and significant step in our registry recording. Once the data is recorded, it cannot be altered. This makes blockchain records highly reliable for use in court or arbitration, especially in verifying ownership histories, transactions, and timestamps. However, courts in many jurisdictions are still developing standards for admissibility of such digital evidence. Blockchain can also facilitate alternate dispute resolution by enabling automated dispute mechanism via smart contracts. It helps reduce ambiguity in agreements, ensures compliance, and may speed up settlement of property-related issues. Transparency in records also discourage fraudulent claims and corruptions. A significant challenge remains, however, with jurisdiction differences in recognizing blockchain data. While countries like Estonia and Singapore has begun integrating blockchain evidence into their judicial systems, others lag behind due to the lack of legal frameworks and digital infrastructure. There is a growing need for international standard to govern the use of blockchain-based evidence. So finally, I would like to conclude by mentioning the future challenges and call to action. We must agree, first of all, that blockchain is transforming property law by enhancing transparency, security, and efficiency and property transaction and governance. However, there are challenges, as I already mentioned several times, about the legal integration, regulatory uncertainties, and cross-border disputes remain challenge. However, we must collaborate among technologists, legal experts, and the policymakers, governments, in essentially to clearly create a cohesive legal frameworks for blockchain in property law because of their very fundamental application and property, which is their opportunities of making the system transparent and traceable. Thank you so much. And that is what I feel that we should make it happen together. Thank you for your attention.